Assalamualaikum dan selamat pagi semua. Okay, saya Puan Syarijah Cik Syari. Okay, first of all, I would like to thank you for inviting me to this talk. But I hope you please bear with me because I am not familiar with the online class. Even though I've been using the apps, but normally I use the apps in the class, not online. Okay, so bear with me. Okay, the topic that I'm going to deliver to you today is on the legal issues in managing employees. Before I proceed to the class, I would like you to go to School Law T, and can you please click on the link Why Do We Work? And I will give you some time for you, say about 5 minutes for you to give an answer. You can answer in Bahasa Malaysia, or in English, it does not matter. Just give your honest answer. Why do you think that we have to work? Do it now. Thank you. You can do it. In the meantime, this is the framework that we are going to discuss today. So part A is on the introduction as to what is law and the background to Malaysian employment law, and part B we're going to look at the contract of service, and part C on the managerial prerogative, and D we're going to discuss on the current employment law issues faced by the organisation, such as dealing with discipline, wrongful, unlawful or unfair dismissal, on OSH. But I understand that you have already had a topic with Prashamso earlier in the morning, so I'm not going to detail on OSH. For your information, OSH is my PhD topic. However, for today, I'll just talk very briefly. Then we are going to discuss briefly on sexual harassment, bullying, and mental health, because these are the issues that are on the rise in Malaysia. And preparing aging society. And finally, I forgot to mention, how are we going to deal with the current lockdown that we face due to COVID-19? And finally, on the conclusion. Are you done? Let's move to the next slide. As you can see here, Shackleton in 1975 mentioned that work is a central feature of modern industrial society. So it occupies much of the time available to most people for the majority of their lives, and the economic rewards obtained from it determine an individual's standards of living and, to a considerable extent, his social status. I believe what Shackleton said in 1975 is relevant even until today. We go to work because we need reward. Just imagine, if you don't get paid, would you still go to work? Then for those who are still working even though you are not being paid, then I really salute you. And inevitably, your work will determine your standard. Your meaning that, let's say for example, if you are a professor, of course the standard will be high compared to if you are primary school leaver. And of course, when we work, it determines our social status. Let's say if someone who's not working would like to ask for your hand of marriage, I don't think you would accept that. So that is why we go to, because we spend more than 8 hours at workplace. Because of that, before I answer, so I want you to just give an idea, why do you think employment law is very important? Can you please click on the second link? What is the importance of employment law? I give you some time for you to dwell on it. You can do it in the meantime. So As you can see from the screen, okay, the purpose of employment law is to govern the relationship between an employer and employee. Therefore, it aims to safeguard the interests of the employer and society in general, and an employee and an employer and employee in particular, so that we can have harmonious relations in a workplace. Therefore, it will enhance the company's or organization's productivity, and therefore, eventually, the nation's income will be increased. So what is law in the first place? Law is a rule of action to which men are obliged to make their conduct comfortable, a command enforced by some sanction to acts of forbearance of class. So meaning that law, there is a set of rules and there must be sanction. Sanction means hukuman. Let's say if there is no sanction, people do not respect the law. That is why when there is law, that it has to be enforced. Otherwise, the public would not respect the law. Let's say we have seen, okay, everywhere that if you throw rubbish, okay, in a public area, therefore you will be compounded. How many of you had actually seen a person being compounded for throwing rubbish on the road? I haven't seen any so far. So that is why people do not respect the law in Malaysia, because there is no enforcement. So all employees have basic rights in the workplace, including the right to privacy, fair compensation, and freedom from discrimination. No longer master and servant relationship. As you can see from from the screen, you could see that how are you going to tilt the balance between the employer and employees' demands? Employer would like to maximize the profit. Excuse me, mind my cough. However, on the other hand, employee would seek for higher salary year in and year out. So, how are we going to make sure that the law it is balanced? The law is balanced. How are you going to ensure that employer will not suppress the employee, and how are you going to ensure that employee performs what is expected from him? So that's why in Malaysia we have tripartite system. Which is consists of government, the employer, and the employee. I would like to share with you some misconceptions. First, normally people will say that employer can summarily dismiss or terminate an employee. Summary dismiss means that by just giving notice accordingly, therefore you can terminate your employee. That is incorrect. The second misconception is that a probationer is not entitled to annual leave, sick leave. As you can see from the screen, that is also incorrect. And there is no contract of service between employer and employee, as they do not sign any document. Normally, among the low-paid employees, they always think that there is no contract between them. So because they do not sign any written document. For your information, contract exists even though it is not signed, because contract can be formed orally. And the most common misconception is that employer has the right to fire and fire. Those days, during the Victorian days, yes, employer is the master. But nowadays, employer can no longer simply terminate an employee without any justifiable ground. So that is why the selection point is very important, because once you have taken in the employee, you will stuck with that employee until he retires, or he dies, or he leaves for another employment, or whichever comes first. So meaning that it will be an unpleasant experience if you chose as an employee who is not suitable with your organizations. This is Latin words. Ignorantia legis neminem excusat. It means that ignorance of the law is not an excuse. So meaning that you cannot just say that, I'm not a law student, I do not know what is the law all about. So that argument is not accepted because you are expected to know your rights, especially when you are in charge of HR, in charge of human capital. Okay. So that's it for the first slide. We'll continue with second slide. I hope you can grasp what I want to say. Thank you.